Good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, Law Offices of Rajiv S. Khanna, PC. We are starting about 5 minutes late today. Sorry about that. Just trying to correct the mistake in the numbers. Let me put the call on presentation mode.
The conference is now in presentation mode.
Okay, let's get started. As usual, I'll first answer the questions that have been posted. We should still have enough time to take new questions. I think we have plenty of time today. So first question is regarding a previous case of ours. In that case, what had happened was that we had a labor certification case filed. Requirements were bachelor's degree and 5 years of experience. We filed the I-140 under EB2. After 8 months, USCIS sent us an RFE saying bachelor's plus 5 would not qualify under EB2 unless the experience required is progressive. We knew that they were wrong, but we did not want to argue. At that time, EB3 was current, so we went ahead and filed the 485. Okay, and just took EB3 because they asked us to take EB3. We said, okay, give us EB3, and we filed the 485. Later on, the priority dates slipped back, and then we filed the I-140 again. And this time we asked for EB2 and we told them to connect it to the already pending case because the EB2 was then current at that time. So the questions that the community member who has posted this has are as follows. So he says, number one, when the EB2 became current, did you file a new I-140 petition? Well, you can file an I-140 petition at any time. The dates don't have to be current. It's the 485 that is the problem, right? So I'm pretty sure we filed the I-140 regardless of whether the dates were current or not. Then you said, isn't there a 180-day deadline on filing? And the answer is yes, but when you are filing for something like this, where the first I-140 was filed within 180 days, and then the second one you file was after 180 days, that's okay. So in other words, when you are filing a subsequent I-140 based upon the same PERM application that was approved earlier and filed earlier with another I-140, you are not constrained to a 180-day deadline. You can do that, okay? Did you file the EB2, I-140, and 485 concurrently? And the answer is, I'm pretty sure we did, but it really doesn't matter unless the priority dates are current. If the priority dates are current, you can file them together, okay? So I think I've answered all your questions. So that's the way that worked. Now there is a question from Kiran about name correction on green card. So the names got flipped. First and the middle name were swapped, and will they reissue the corrected card? And the answer is they can. Okay, when the service request has been opened, case is still pending, they can correct the card. And minor corrections can always be made even after the card is produced. So in a situation like this, this is not a serious problem. Of course, it needs to be corrected, but it's not a serious issue. Don't worry so much about it. Okay. Then now during the time of correction, is my status still a green card? And the answer is yes, of course. The only thing here is that there is a minor typo in your green card, but it doesn't take away your green card status. They will not cancel your green card for this. Okay. Do you have any suggestions for getting my name corrected in the right order? No, I think you're doing the right thing. You have to go through the service request process. Your lawyer is doing the right thing. Can I explain the impact to green card from I-140 revocation by employer after green card approval? Doesn't matter. Once green card is approved, you have nothing to worry about. Okay. I think, Kiran, I got your questions. So next one is Arjun. He wants to know H-1B and green card move from company A to company B. So I-140 was approved by company A. They have filed an H-1B for another 3 years. Okay. So questions are, after my H-1B renewal is approved from company A, if I move to new company B, will H-1B still valid for 3 years? The answer is probably yes. USCIS is a little inconsistent in these cases. So let's say you've got your 3-year approval from company A, then 8 months later you want to move to company B. Will you get 3 years again, or will you get 2 years and 4 months? And what they've done is sometimes they give you 2 years and 4 months, and sometimes they give you the entire 3 years again. Okay, they're not consistent in this. After 3 years with my company B, say in 2017, can company B still renew my H-1B for another 3 years based on the I-140 approval for company A? Yes, they can, if company A has not revoked the I-140. Can company B use the priority date of company A? Yes. Even if company A has revoked the I-140, company B can still use the priority date, and they will have to start the green card process from scratch. Perm, I-140, and 485, the same one can be used. If the I-140 is still pending. If it is not pending, then you can always refile the 485. Okay, next question is from porting need, porting EB3 to EB2 with change in nature of job. So here the situation is very interesting. Bachelor's in architecture degree, 5 years of experience in 2-3 different architecture firms, but decided to change career. Did a bachelor's in nursing, and now he's a nurse. Okay, doesn't have any IT experience. Objective: I want to port my priority date to a new EB2 so that my spouse can also get green card. Spouse is just came back to US and is looking for a job on a recently approved H1. Questions: how is 5 years experience proven in EB2 application? Through experience letters, and please make sure they are accurate and truthful. Can 1 year in nursing be seen as similar progressive job after 5 years architecture? No, these are completely different jobs. Can an IT firm consider my 5-year architecture AutoCAD software designer experience as an IT job? Very doubtful. Very, very, very doubtful. It's like saying I've used Microsoft Word. Can that be considered to be IT experience? CAD is just another application. Using CAD does not make you a programmer or a systems analyst. My previous architecture employer, whom I left in 2007, can sponsor EB2 in good faith for senior civil architect type position. I can take care of all legal procedures. You cannot pay for a green card. That's illegal. At least the first half of the green card process, which is up to the perm application, they have to pay. That's required by law. I can engage an attorney, but is it advisable that a small firm with no immigrant petition history file my EB2? If they have enough money to support your salary, yes, absolutely. It doesn't matter. We've done cases for one employee firm. Of course, we've done cases for much, much larger companies, Fortune 50 companies, but even one employee companies can get approvals. Last is there a chance that my spouse can file EB3 using my priority date? No, they cannot. Your priority date cannot be transferred over to your spouse in such manner. Okay, so it looks like you don't have relevant experience unless you go back to architecture. You cannot do an EB2, it doesn't look like. Vikash 1234, visa expired but I-94 is still valid. Okay, remember one thing. Visa is merely a permission to enter the United States. So let's say my visa is valid until tomorrow. But I enter the United States today and I got an I-94 for 6 months. I can stay in US, say, up to 6 months because I've got an I-94 for 6 months, even though my visa is expiring tomorrow. Okay, so your stay in the United States is determined by a valid I-94, not by a visa. Let's see. So so he says I'm on L1 visa. Visa is going to expire in April 2014. I-94 would expire in October 2014. I know I can stay till I-94 is valid. You not only that, you should also be working. You cannot just stay because you have an I-94. If you're on an L1, you've got to continue working on an L1. So my questions are, as per 2013 new immigration rules, there are no new immigration rules. So I'm not sure what you're talking about. Can I stay in US till October 2014 based upon I-94 rather than visa? I already addressed that issue. Would it cause any issues in the future? No. If you're still working, your I-94 governs your legal stay. If I apply for H-1B through a sponsor next year 2014 and the application process fails, will this impact or reject my application to L1 to H1 change of status process? I'm not sure what you mean by that. I'm not sure. I have no idea what that means. But if you are validly working on L1 and your H1 gets rejected, your L1 application is not affected. Okay. So denial of H1 has no impact on a valid L1 which is continuing. I think that's what you're asking. Next question is Sonia Tandon. Okay. H1B petition and stamping. I'm in India. My H1B was filed by company A. I never went for stamping with company A. Employer has not withdrawn the H1. Company B wants to transfer my H1B. If the stamping gets rejected, can I still join company A? As long as they have a job for you, you can. But the problem, Sonia ji, is this. Your first employer has waited so long for you that CBP at the airport or consulate can raise the issue. How come if they have a job for you, they have waited so long? If you have a good explanation for that, you should be able to get a visa with company A even after B's rejection. And you can, of course, enter with company A's visa stamping as long as you have an explanation. In case company A withdraws, stamping gets rejected with B, can I search for suitable employer C who can file cap exempt H1B petition? The answer is yes. You can still go with C and you'll be cap exempt as long as the first H1B approval was within the last 6 years. If answer to point 2 is yes, which it is, which petition copy will be required? Company A's. Company A's. Company B, we don't care about that much. Okay. Vishal Pratap, traveling during H1B transfer. Okay, guys, remember one thing. When you're doing a change of status, like F1 to H1 or H4 to H1, you should not travel, because if you travel, then you have to wait outside, get the approval, get a visa stamping, and come back in. But when you are doing a transfer extension amendment, it is H1 to H1, you can travel. You can travel. Okay. So should I be returning both I-94s at the point of exit if I get 2 I-94s through this method? And the answer is yes, of course. There is no problem with this. Even if you have 2 I-94s, it's okay. Because if you have one through approval, one through entry, so what? It's fine. Next question, AAGAR 2003. H1B stamping and F1 OPT to H4 conversion for spouse. Watching your video on C-SPAN, good. I'm glad you like it. I thought it was rather boring, but okay. I was in India 1 year before I had F2 visa based upon my wife's F1. I worked for a company in India who filed my H1B. I did not travel to USA for that position and or role, but I did get the visa stamped. Beginning this year, I entered on F2. You cannot use that visa. I don't think you can. Subsequently, you got an H1. I don't think consulate would want you to use that visa. I know that they've been creating problems for people like this. If you change the facts, let's say you entered USA on H1 visa, started working for that company, then changed companies. Do you have to get a new visa? The answer is no. I don't see the difference between your situation and the situation I just mentioned, but the consulate, I think, will not let you use that old visa. They would want you to get a new visa stamping. Can you go to Canada? Sure. The only time you cannot go to Canada or Mexico or third country other than your home country is if you have been out of status in the United States. Okay. So can I guess? Okay. Third question is, my wife has been on OPT for the past few months. She's got 2 months left. When should I file for H4? After the OPT, she's got 60 days. You can file her H4 during those 60 days, grace period, and you can do it online. That's very easy to do. If we get her visa status converted while being in USA, can she stay in USA on H4 while I am out of India to get my visa stamped? Yes, she can. If you are gone for a long time, 6, 8, 10 months, then she cannot stay in the United States. But if you've gone temporarily, just for a few weeks, I don't think USCIS will have any objection on her getting an H4 and staying on H4. If she goes to get her H4 visa stamp while I stay in the US, wouldn't she be required to get my visa copy as well? It depends upon the consulates. Sometimes they insist that before they are going to issue an H4 stamping, they want to see an H1 stamping. Sometimes they don't ask for it. Okay. Deja vu. Salary increase to match prevailing wage after green card approval. So here what has happened is green card is approved, but they are paying 7% less than what they should be paying. So should I continue to work at the current salary or leave the employer immediately? I look, as long as you are there and you have made yourself available and shown yourself as willing and able to work, if the employer refuses to comply with the conditions, I don't think USCIS will take away your green card. There's no law on these issues, but I don't think USCIS will come after your green card. That would be my guess. So what can you do? You should document the fact that you told the employer that, look, I want to, get my proper salary and I'm available for work. Please go ahead and raise my wages accordingly. And if they don't do it, you could leave. And I don't think, and even if you stayed, I don't think your green card will be in jeopardy. Usually bonus cannot be counted in salary unless the bonus's amount is guaranteed. Okay. So I don't think you need to worry about the green card getting lost. That's very unlikely. Nindaji, I don't know anything about asylum. So you have to forgive me. I don't do political asylums. So my knowledge of political asylums is very, very limited. It doesn't look like it should be a problem if you send your baby to Nepal, but I would not want to comment authoritatively because this is not my field. Okay. Milind Shah says, he's mentioned a company name and said that this company appears to be misusing employees. Look, I really cannot comment about that. And I normally advise people not to put down company names, etc. It's not a good idea. So if the company was doing something that was against the law or it had caused some problems for the employee, I don't think you can take much legal action. You can complain to the government if you know of anything, concrete. You can complain to ICE if there is any violations of immigration law. You can also complain to the Department of Labor if there is any violations of labor laws or wage and hour laws, like they are paying you less salary or they are violating conditions of the LCA. But you filing a lawsuit, etc., against the company is very unlikely. You can explore that with some local law firms. I would not spend too much time doing that. Okay. Because largely immigration law is a matter of intention. Employer intends to do certain things. If they don't do it, are they necessarily actionable? Not unless they are breaking the law. Okay, and just because they are quote unquote misusing their employees, if there is no violation of the laws, I don't think you have a cause of action. Okay, I hope you're on the phone. You can maybe tell me more about this. Let's see if you are here. But I don't understand exactly what the issue is. It doesn't appear to me that there's going to be any cause of action against the employer. Emain wants to know, I lost my green card, had to file for replacement before I left USA. Okay. Want to apply for US citizenship, but my green card hasn't been issued. Can I file for citizenship? To the best of my knowledge, yes, you can. I remember cases where we've done this before. So yeah, you should be able to, as far as I know, with a copy of your receipt of the replacement application, you should be able to file for naturalization. But you can double check with the USCIS directly through the customer service, or contact your congressman. They can get you that information. I think you can. Int2 wants to know H1 transfer and risk associated with it while amendment is in progress. Working with a client on EVC based model, which is end client vendor, I guess employer vendor client model. There's a material change in my employment. Job duties and designation is the same, but working with client as compared to in-house. LCA was filed right when this happened. Now the amendment has been filed. See, amendment should have been filed right away, not just the LCA. Now, that can put you out of status. While above is going on, I have a good opportunity to join the same client with a different line of business for which I applied long time back. They're willing to do the H1 transfer. So scenario is I am accepting the full-time position, asking the company I'll start working for them only after H1 approval. Current employer has filed the amendment, the decision is pending. So question number 1, if my transfer gets denied, will this affect my current H1? No. Can I continue my present job without problems? I think you already have problems because amendment should have been filed earlier. 2. When the new company files for transfer, can USCIS ask regarding the amendment process? Normally they don't. Normally they don't. Should I wait for amendment to be approved and then trigger the H1 transfer process, which is the safe way to go? I think you should file the transfer because I'm concerned that the employer's conduct may have put you out of status. Having a transfer at least gives you a chance of going for the visa stamping right away. Okay. The next question is about 212A4 denial, where the problem is because the person who gave the sponsorship is not domiciled in the US. So the embassy is saying, the consulate is saying, we are denying this case because there's no proof of domicile. You need to get yourself a lawyer. Your understanding of the law is correct. As long as you can show that you are in good faith re-establishing domicile in the United States, they should not be able to deny on those bases. But in order for somebody to argue the law with them, you have to get a lawyer involved. I don't think you can handle this by yourself. Okay. Rohit, L2 to H1 transfer within USA. I came to US on L1 visa, applied for L2 for my wife, and I guess she traveled on the same. Wife is also holding valid H1B for next 2 years. Once she reaches US on L2, can she find an employer and transfer the status from L2 to H1? She can. I don't see any problem with that. But also remember one more thing. On L2, she gets EAD anyway, employment authorization. So she can be working right away as soon as she enters and gets her EAD. B2 visa holders' passport got damaged. Mother came to USA on visitor's visa. Passport got damaged by water. Photo and first page are shaded. Rest of the details are perfectly visible, including her visa. Passport is expiring in 2021. US visa is going to expire in 2016. She's leaving in a couple of days. Will she have any problems going back to India? Not at all. Not because of the visa. Now, because of the passport, that's something you've got to check with the Indian embassy. You've got to call the Indian consulate, explain to them what happened. They are the ones that can tell you because the question is of Indian laws. Question is, can she enter India? Leaving USA is no problem. Can I apply for reissuing passport for her in USA? Yes, you can. Yes, you can. Kala wants to enter USA on a tourist visa and get married to fiance who is doing master's degree. Don't do that. USCIS can consider that to be fraud. Okay. Now, I know people who've gotten married and then gone back instead of trying to stay here. But I find it objectionable that you enter USA with the intention to get married because tourist visas are not supposed to be used for that purpose. Okay. So you should go the route of getting married outside USA and come in through F2 or H4, whatever is available. I would not recommend this method. And we've been very quick. Last question is this. Parents had their naturalization interview. Mom has passed civics test and reading test, but didn't pass writing test. Does she have to do this whole thing all over again? That's up to the inspection officer. As far as I know, there is no specific law on this issue. How long will it take to schedule for second interview? Depends upon the local times. I cannot really tell you. I went to India to finish my leftover study and stayed for 182 days. Will I have problem with my citizenship? You will not. If you have a good explanation and your stay is more than 6 months but less than 1 year, your explanation should work. Okay. And lastly, this forum helps me a lot. Once again, I would like to say thank you. I am delighted. I'm so happy to hear that. It's always a pleasure to make things available that can help people. Okay, folks, I'm done with the questions. Any follow-up questions, press *5 on your phone. Any follow-up questions, *5. If you press *5, I will see that you have a question. I will then talk with you one-on-one. *5. Did I give you the right, or is it 5-star? It should be *5. No, it is right. *5. Okay, I've got one question. Follow-up question 1. We'll do new questions after this. 1 second. So only one follow-up question. Go ahead. Milind, go ahead.
Hi, Rajiv. I just wanted to see if there's a way I could have a one-on-one free consultation with you. I mainly wanted to review the employment termination and the release agreement letters that the previous employer has provided to me.
And
I wanted to review it with a lawyer before I signed it off.
This is a Virginia company?
Yeah, the company is based in Reston, yes.
Okay. Here's what you do. Send me an email to help@immigration.com. Help@immigration.com.
Okay.
Attach the documents. Tell me what you need to know. I will tell you what we will charge for the consultation.
Okay, sounds good.
Okay.
I will send it to you right away.
Yeah, absolutely. No problems. Good luck, Milind.
Thanks.
All right, bye-bye.
Thank you.
Bye. What did I do? Okay. All right. Anyone has any question whatsoever, new question, press *5 on your phone, please. Any question? 1, 2. Very good. Only 2 new questions. That helps. And these are, I'll take them in the order in which you guys logged into the call. Okay. So let's begin with the call from India. Go ahead, please. The call from India. Go ahead, please.
Yeah, that's me.
Yes, ma'am. Go ahead. I can hear you.
Yeah. Hi, Rajiv. Okay, Rajiv, my kids are US citizens, minors, both of them. I'm in India. I have a B1, B2, used to be on H4 7 to 8 years ago. My question is, I want my kids to study in the US. Is there any provision for me as a parent to stay with them while they pursue their studies?
Okay, I think you posted this message on immigration.com also, didn't you?
Yes, I did, but they're showing me that it is not going through.
Oh, really? Because I have
responded.
I have responded to your question on immigration.com. And here's what I said. I said, even though now let me understand the situation. Your voice is not very clear, but I think I've understood your question. Your question is, my children are US citizens. I am not, and they want to study in the United States. Can I stay with them while they're studying?
Correct.
Okay, and the answer is, I know at least one case within the last few years where a mom was able to do that with her kid. And what they did was, when they applied for the mom's tourist visa, they told the consulate, look, I want to live with the kids as long as I can, as long as they need me to finish up their schooling. Okay? And we'll keep extending the tourist status when we are in the United States. If the consulate gives you the visa, then you have to declare that intention again at the airport. When you land at the airport, you tell them, look, I'm here to, I told the consulate what my need was, and they gave me the visa, and now I'm telling you the same thing. I would like to keep extending the stay year to year. So they would do one of the three things. Either they'll say, no, you cannot come in, or 2, they'll give you 6 months, and you'll keep extending it 6 months to a year, depending upon what USCIS gives you. Or the third possibility is they'll give you 1 year, and then you'll keep extending year to year. I have seen all of these possibilities happen. Okay.
Okay, but the problem is I didn't mention this while getting the visa.
I'm sorry? What did you say?
I already have a B1, B2. I didn't mention this while getting the visa.
That's problematic. I think you should go back and apply for a visa. Well, then I'm going to send them an email. Let's do this. Let's start from here. Okay. Send them an email. Say, this is my situation. Do you want me to come back for a visa stamping? If they say no, go ahead and take a printout of that email and land up at the US airport.
Okay.
Let's
and then
try
mention
that.
to them that this is my intention.
Yeah, and drop me a mail, help@immigration.com, if there is any
Okay.
follow-ups, and if we need to talk again, I'll bring you out in the conference again.
Right, I get it.
Okay.
Okay, and so is there a possibility for me to change my visa from B1 to F1 maybe? I could study at the same time probably and
You
be with
can
them.
you
Would that
can
be a possibility?
you have to declare that intention at the airport. There is a regulation on
At
the
the
books
airport.
that
Okay.
says if somebody enters USA on a tourist visa and they want to convert to an F1, they will not be allowed to do so unless they have
Right.
declared that intention at the airport.
I see. Okay, that makes sense.
Okay?
Okay, that helps.
Yeah.
So I will drop you an email also, and I will drop them also an email, and we'll see how it goes.
Now, drop me an email after you heard back from them. I would like to know what they tell you.
Fine. I'll do that, sir. Sounds good.
How
Okay.
old are the kids? How old are the kids, ma'am?
That helps.
Ma'am, how old are your
I'm sorry?
children? How old are
8 and 10.
8 and 10? Okay, yeah.
8 years and 10.
Yeah, I think that's a legitimate
Yes.
need. I think they should allow you to enter.
Really? Okay.
Yep. Okay.
Okay.
Good luck.
We'll see how that goes.
All right.
Thank you so much for your help.
You're welcome. Bye-bye.
That helps. Thank you. Your voice is cracking, sir.
Yeah, no, that's fine. We're done. Bye-bye. Okay, last call is last question. Chicago, go ahead, please.
Hi, Rajiv. So I have a couple of questions regarding my application for my parents to get their green card. I'm a U.S. citizen. If that's okay, since I'm probably the last question here.
Oh, take your time. No
so basically, my mother and father came in the U.S. on tourist visas. They came in separately. They didn't intend to apply for a green card, but then I convinced them to do it after they got here because we moved. They like the city now, and I also give to a baby, so they want to spend some time with their grandchild. So we received an RFE for my mother. Actually, we received an RFE for my father, which I replied, and they separately issued an RFE for my mother. Could I submit the RFE at the interview? They also got an interview notice as well. Or do I still need to send the RFE in separately?
I would make 3 copies of the RFE response. I would carry one by hand, one I would mail to the mailbox address, and one I would mail to whatever address you got the notice from for the interview. I would do that just to make sure that whoever is going to review the application at least has some hope of getting the RFE response in hand beforehand.
Okay, I see. Second part of the question is I'm self-employed and I file for tax returns with my husband. So because I'm self-employed, I don't have a W-2, and the two of us combined would have definitely sufficient income for applying for the to sponsor their green card.
Sure.
Now it's very hard to separate what's his income, what's mine, and so on and so forth. Do I need him to sign a sponsorship paper, or can I just do it myself?
That's simple enough. Do it yourself first. If they don't like it, he can always co-sponsor.
Okay.
They're not going to deny the case. They're not going to deny the case outright. They'll give you a chance to provide a co-sponsor affidavit.
I see. Now, another related question is that they asked for my parents' birth certificates and so forth. I had my father prepare for his English translated birth certificate when he was back home, and so they would see the date that's before his entry into the U.S. on a tourist visa. At that time, I didn't tell him the purpose was that I wanted to apply for a green card for them. I kind of, it was a white lie. I told him that I wanted to apply for citizenship and that required his birth certificate. He didn't know better, so
Liar.
He did what I asked him to do.
Liar. Lying to your parents, shame on you.
Sorry. No, to protect him legally. So does it, if the question was raised at the interview, so how come the date for preparing your birth certificate is before his entry? Can I tell the interviewer that, or is it going to cause
Well,
trouble?
this is the way I would approach it. Let me tell you what the legal problems here are. Is it okay for a child or or an offspring to lie to their parents legally under immigration law and have them come in on a tourist visa when she intends to apply for their green card? Probably not. Probably not. Government could take the position that, okay, even if they did not commit the misrepresentation, you did. And that's kind of silly carrying it so far. But my argument to that would be my intention is to convince them. There is no way I can file for them without their consent. I will never do that. Okay. So really, there is no fraud here, because even though I was hoping that the documents would be in place and maybe I can convince them while they are living here, and maybe being around their grandchild would convince them. But there's definitely no preconceived intention here either way. But to avoid that argument altogether, I would just provide a new translation. What is the problem there? See, remember, immigration documents can be translated, immigration-related documents can be translated by anyone. Okay? All you need to do is, at the bottom of the translation, you would append a statement. You can write it down if you want. You'll say, I, whatever the name is, Tom, Dick, and Harry, comma, do hereby certify that I'm conversant with both Hindi and English languages, and that I have translated the preceding document fully, completely, and to the best of my ability, or fully, accurately, and to the best of my ability. Signed, dated, name, address. Okay, anybody can do it. Okay, so why even?
The only issue.
Why even?
Yeah, the only issue is that the birth certificates were already submitted in the original package to the. They have a copy. So.
I suspected that. If they're already submitted, not much we can do about it. Let it go. If it comes to that, you're gonna need to hire us. I'm gonna have to argue with them, but I don't think it'll come to that. Okay.
Okay.
So I think you'll be fine.
All right.
Good luck.
I see. So so just a couple quick follow-up. What are the things that we need to be mindful of, or typical questions that they would ask for a case that parents come in on a tourist visa and now I'm applying for their green card?
When did they enter U.S.?
At the interview.
When did they enter? When did they enter?
Oh, when did they enter? My mother entered in the spring of 2012. She extended her visa, her 6-month stay once. The purpose was not to, apply for a green card. She had some problems with her teeth. She had to get treatment here, and that required a few months. That's why she extended her visa. Okay. And then my father entered in January of 2013. I filed for their green card, submitted that in May of 2013.
I think you'll be fine, because if it's more than 60 days after they entered, they should be okay. They probably will not be asked about their intention.
I see. Okay. And do they tell you if they approve the green card right at the interview, or they just say that we have to do more work?
They can do it either way. Sometimes they'll tell you right away, okay, I'm approving it. You'll get an approval in mail. Sometimes they'll say, I have some more work to do. You might get a request for more evidence later. So it all depends.
I see. And do you, I think that they would if they get approved, they'll get a stamp on the passport first before they get the card, right?
No.
They travel with that stamp?
Hang on. They don't stamp passports automatically. Okay?
Okay.
If they need to travel, they should go ahead and make an InfoPass appointment, go in with the approval notice, and get the passport stamped. And that stamp is as good as a green card. They can travel anywhere with that.
I see. Okay. All right.
Okay.
And okay, so it's not necessary. Okay, gotcha. Thank you so much.
You're welcome. Good luck.
Oh, one last thing I forgot. Let's say if my own income, let's say they somehow wanted me to separate my income from my husband. Let's say my own income, for the last year is insufficient to apply for the green card. I have a bunch of savings, and I can show them my savings from the bank and so forth. Would that take care of the issue? It's like 5 times of the required amount, which is fine.
No problem.
And do they like it, or do they hate it?
Well, they don't mind. All these things they are all a part of the consideration of the ability to support your parents. So
Mm.
I cannot predict. I don't know the numbers. I don't know what's going on, but it looks like it should be sufficient.
Mm-hmm.
Okay.
Okay.
But otherwise, you can
All right, thank
always
you so much.
you can always have your
Yeah,
husband
go ahead.
you can have your husband co-sponsor. It's not the end of the world.
Mm-hmm. Okay.
Okay.
Great, but I'll get a chance to do that. They wouldn't just deny,
Oh
right?
yes, ma'am.
Okay.
Yeah, yes, you will. Good luck.
Okay, great.
Bye bye.
Thank you so much.
You're welcome. Bye.
Okay.
Okay. I guess we have one more question that came up. Sir, go ahead. You were, I think, pretty much the first guy who logged in. Go ahead, please.
Yes, Rajesh, thank you very much. Actually, I used my 5 years of H1B until December 2012, last year. And for this year, 2013, I have been traveling. I have been spending 3 months in India, 2 months in US, and back and forth due to my family situation.
Okay.
Now everything is resolved. I would like to go back to my job. So according to that, I am on a B2 visa right now in US, and I got my Mexico visa as well as Canada visa.
Okay.
I'm just planning to go to either Mexico or Canada for stamping, which is from B2 to H1. Not exactly the B2 to H1, just going there and then getting a H1 stamping after my H1 renewal petition came up.
Sure.
Which consulate do you suggest, Mexico, Matamoros, or something in Canada? Do you have any suggestions?
I am not sure that there is such a thing as a good consulate. I think it depends upon the consular officer. It depends upon the facts of the case. In my view, as far as I know, both are equal. You can go to a consulate in Mexico or Canada, or a consulate in Canada, whatever is geographically more convenient to you. I'm not aware of any specific recommendation anybody can tell you this is best and this is not best. So I think they're both the same.
Okay. And since we discussed in the last conference call, even a person is on B2 visa, they can still apply for the H1 renewal, and then they can file the LCA and then H1 renewal as well. Once they get the approved petition, they can travel to Mexico or Canada for the stamping.
They should not do a change of status. That becomes problematic. And also, it should be clear that when they entered USA, it wasn't their intention to just apply for H1B. They had a legitimate reason to enter.
Yeah, there is a legitimate reason, and then it's not a change of status application. It's just a H1 renewal application.
See, I'm talking about two different things now. I'm also talking about, okay, you can't do change of status, but also your entry on tourist visa or B1, B2 visa should have been for a specific reason. It should not have been just to apply for an H1 and then go to Canada or Mexico to get visa stamping. Even that is probably not a good idea. Change of status is a complete no-no, but the entry on tourist visa should be legitimate. Okay.
All right, thank you.
Good luck.
I'll keep you posted on that.
Okay. All right. Take care, sir. Well, good talking with all of you, and I will see you again in 2 weeks, folks. Happy holidays to all of you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.